Can a wealthy individual use the court system to silence critics? Unfortunately, yes, and I hope my story and what you'll watch in this video highlights how wealthy fraudsters can use lawfare to silence critics. In June 2021, I was sued by Derek Moneyberg, who happens to be very wealthy. I've made numerous videos in a series discussing him and my case. On September 29, 2023, we won the lawsuit in district court. In legal terms, we were granted the motion for summary judgment. Derek Moneyberg didn't like the outcome, so he appealed the ruling in October 2023. We finally had our oral argument day in appellate court on December 9th, 2025. That's right, it was over 2 years just in appellate court. That is nearly 5 years for the entirety of the case, but we did receive the order recently ending the case. The appellate court ruled in our favor, dismissing the claims of defamation, intentional infliction of emotional distress, and business disparagement, and affirmed the dismissal of the Lanham Act claims. That means it was a complete victory on the merits of the case in both courts. That's the good news, but now let's discuss this within the context of YouTube. Whether it was iDubbbz in his Content Cop series, H3H3 making fun of cringe content, CoffeeZilla exposing another fraudster, or clips from any number of commentary channels. YouTube is great when creators can call out other creators without fear of being financially ruined if that other person didn't like what they had to say, until you run into someone who is enough of a villain to file a lawsuit. This lawsuit was filed in federal court, specifically the U.S. District Court for the District of Nevada. After winning in that court, the case was appealed in the United States Court of Appeals for the Ninth Circuit. That was a mouthful. My appellate ruling is binding precedent on every federal district court within the Ninth Circuit. I include the other states on screen that could apply my victory. The most notable states are California, Nevada, and Arizona for content creators. In lawsuits, attorneys use the rulings in other cases as precedent for how the judges have ruled before. This ruling is binding law in the Ninth Circuit and persuasive nationwide, which means it could directly affect how lawsuits against creators in the future are evaluated. Now let's discuss how wealthy people can weaponize the legal system to their advantage. This was a slap suit brought by a multimillionaire who got that way by scamming people out of their money, as defendants reported on. To keep his scam afloat, he sought to stifle anyone who tries to criticize him with what is colloquially referred to as lawfare, or a slap suit. To Buchkovsky, a few $100,000 thrown at an underfunded defendant is just the cost of keeping the scam going. More on what a slap suit is in just a minute, but in case you aren't aware, here in America, a wealthy person can sue an underfunded defendant and essentially ruin their life for many years, and in some cases bankrupt them. In case you haven't seen my videos discussing the case, the videos that resulted in the lawsuit are of me interviewing John, who is a YouTuber in the dating coach space. This was a much different time in my YouTube career back in 2020. All I did was interview John and ask him questions. I did not make any false statements of facts, did not make any accusations, and I certainly didn't make any opinions that would be considered defamatory. Yet, I was the one who was sued. In addition to a defamation claim, Moneyberg included the Lanham Act claim in the complaint strategically. One aspect of the Lanham Act is basically false advertising. Essentially, a competitor said a false statement of fact about a business's product or service. This was a meritless claim, but it's a federal claim. So instead of the case being entirely in the state of Nevada's court, it went to federal court. The case is dragged on for over 54 months. Meanwhile, had it been properly brought in state court without its absurd Lanham Act claim, there would have been limited, if any, discovery and a quick and far less expensive resolution. Mr. Moneyberg properly calculated that he had more money, so federal court was where he held an advantage in a war of attrition. We proved that Buchkovsky materially misrepresented his state of residence. He could have simply claimed diversity jurisdiction since he is provably an Illinois resident. However, he sought to hide his true residency for some reason, presumably as a state tax evasion strategy, so a federal question was the only way to avoid litigating his state law claims in state court while maintaining his subterfuge. This is just one of the many unethical and, in my opinion, illegal tactics used by Moneyberg and his counsel throughout this process. But anyway, federal court is a lot more costly and takes a lot more time than just state court. There's also tactics employed to increase the billable hours. This image of me on the screen is from October 2022 when we went to court. His counsel was being incredibly difficult just scheduling depositions. So we had to go to court and get a judge to help us schedule a deposition date. It was like hurting adult children. This incident cost me $5,000 alone. Throughout a 5-year case, when you're dealing with Moneyberg and his counsel and their intent is to just ruin your life, there's so many tactics that you can employ that just keep the billable hours running. When I recoup my money from this situation, I know exactly what I'll be doing. I will be investing on the platform of today's sponsor, Webull. Easily invest in stocks and ETFs with Webull. You can start small with fractional shares and trade commission free. If trading or investing sounds scary to you, you'll absolutely love this feature. They have a powerful paper trading application that allows you to to trade with fake money so you can gain the skill and experience of trading without the downside of losing real money. What makes Webull the best application for trading and investing is they offer many different asset classes. On a single exchange, you can invest in stocks, ETFs, trade options, trade crypto, futures, and many more. But here's their newest feature, just in time for the big game this weekend. They have their own prediction market, which allows for a much more enjoyable experience trading the outcomes of sporting events. Being an FCM regulated platform, it gives customers the ability to trade prediction market contracts with transparency and oversight. Watching Webull's prediction markets is a neat way to see how people's expectations shift as the events approach, and analyze the odds of in-game options like a specific player's number of touchdowns. Webull is offering $0 commission on all trades for big game related event contracts. Customers can place trades without paying a commission for the executed trade. However, exchange fees still apply. Scan the QR code on the screen right now or click the link down in the description to get started on Webull today. Now let's discuss why the anti-slapp is important for everyone in media, reporting, journalism, and YouTube content creators. SLAPP, Strategic Litigation Against Public Participation. Those of us reporting on fraudsters or unethical behavior by scammers or celebrities or influencers are vulnerable to a wealthy litigant utilizing the legal system to try and silence criticism. Moneyberg's case against me is the textbook definition of a slap lawsuit, a wealthy guy upset that someone reported on his unethical behavior or scams. Lawfare is essentially using the extreme cost of litigation to shut up or silence critics. The anti-slapp special motion to dismiss is our best defense against those who engage in lawfare. The most important elements of the anti-slapp are that defendants recoup their full attorney's fees and a $10,000 reward on top. That's supposed to be the deterrent for lawfare. The problem is that it isn't enough of a deterrent for someone wealthy enough like Moneyberg who has enough animosity to not worry about what could be $1 million in legal fees. The anti-slapp is typically filed at the beginning of the case, which stays discovery, which means we'll put it off until the judge rules on the anti-slapp. But there's ways around that, like Moneyberg filing a meritless claim, which we thought our best strategy was to go through discovery, because if you get the anti-slapp denied at the beginning, you aren't able to use it at the end. The Institute for Free Speech website has a cool graphic for which states have the anti-slapp motion. Currently, there are 39 states and the District of Columbia with the anti-slapp motion available to defendants. They even provide a grade for each state. But what matters most at the end of the day is what the judge decides. The judge didn't grant my anti-slapp in what can only be considered a confusing ruling and just a complete mistake. In the order filed with the court back in September 2023, in order to win the anti-slapp, you need to prove that the good faith communication must be either truthful or made without knowledge of its falsehood, and it must have a direct connection with an issue of public interest. Basically, you're talking about someone that is of public interest, a public figure, and you need to prove that you had no knowledge of falsity of any of the statements or you didn't act with reckless disregard for the truth. Keep in mind that I never made any statements at all, no accusations, and no wild opinions that could be considered defamatory. I simply interviewed a credible source who had first-hand experience dealing with Moneyberg. Taking plaintiffs at their word in their complaint, the court finds that they are public figures. This is important because this satisfies the communication being of public interest or about someone who would be considered a public figure. Here, all of the allegedly defamatory statements were uttered by Mulvihill, not Cornelia. Cornelia was simply interviewing Mulvihill. Thus, plaintiff's claim is more appropriately directed at Mulvihill. Regardless of this fact, the evidence in the record shows that Cornelia did not act with reckless disregard in conducting his interview with Mulvihill. As described, Cornelia published his videos based on reasonable information he received from reliable sources. Even the court agrees. That's their wording. They're basically implying that the lawsuit should have been filed against the guy I interviewed and not me. Even if Cornelia were mistaken, his conduct is not remotely close to constituting reckless disregard. Thus, defendants did not act with actual malice. In their order, in their own words, the court literally asserts both prongs of the anti-slapp. They're saying, you need both of these things, and we're asserting you did both of these things. While defendants do not satisfy each individual criterion under Nevada's anti-slapp statute, the court denies defendants' special motion to dismiss. They literally contradicted themselves in the same ruling. In detail, they described how I met both prongs of the anti-slapp, and then in the paragraph with their ruling, they then claim I didn't. I bring this up because even if you have the strongest argument and all the letter of the law on your side, the judge can just turn their brain off and rule against you. That is the vulnerability of going to court, and the reason why wealthy people can sue, because there's a non-0% chance that the judge just mistakenly rules. Moneyberg appealed because he didn't like that we won. And it gets worse. Here's the part that was even more frustrating. Had the district court granted the anti-slapp, Moneyberg, when he wanted to appeal, he would have had to post the judgment amount in a what's called a supersedious bond, basically a third-party escrow company. So when the appeals process is over, I just collect from the bond. I don't have to chase Moneyberg at all. In our motion for fees at the district court level, we calculated around $330,000 in total should be awarded to me. I've now had to spend a significant amount of more money at the appellate court with no guarantee of recouping. Had the district court just granted the anti-slapp like they should, I would be recouping $330,000 from that supersedious bond in just a couple weeks, and then the money from the appellate court would come just a couple months after. The appeals process is just another way for a wealthy litigant to delay the outcome, put more financial strain on an underfunded defendant like me, and possibly get a Hail Mary attempt at another judge that would make a mistake and rule in their favor. Here's the Ninth Circuit Court of Appeals located in San Francisco, California. The importance of the appellate court is to apply the law correctly and affirm or deny the district court's ruling. We'll get to how this affects the anti-slapp in just a minute. Here's the docket calendar for recent entries. On December 30th, we received the ruling from the appellate court. I shared the image earlier that they affirmed the district court's ruling, meaning they agreed. Well, here's the following paragraph. There is no need to address their special motion to dismiss. That is the anti-slapp. Accordingly, we dismiss that appeal as moot. I was incredibly frustrated when I first read that because the last few years I've had to deal with every day waking up knowing that the district court incorrectly ruled on the anti-slapp, how much better my life would be if they properly ruled on that. And now I'm finding out that the appellate court, the second court, they're not even going to rule on it. They're just going to dismiss it as moot. On January 8th, we filed a petition for rehearing for the appellate judges to rule on the anti-slapp. If it ceases to exist in the District of Nevada because winning a summary judgment renders it moot, then wealthy slap defendants can stand there, but poor and middle-class people will have no access to justice at all. That consequence of this error cannot be ignored by this court. My lawyer is the best when it comes to First Amendment and anti-slapp cases. Some of his motions are pretty funny, and I have good news. The following day, on January 9th, an order was filed directing Moneyberg to file a response to our petition for rehearing. This indicates that the panel of judges in the appellate court have strong belief that they should rule on the anti-slapp, and in the motion that my attorney filed, there's reason to believe that we should be granted the anti-slapp. They're essentially telling Moneyberg in their order to file a response that, hey man, we're going to give you one last chance to try and convince us why we shouldn't rule on the anti-slapp. They even filed a petition for rehearing as well because they once again didn't like the outcome. They're trying to argue that Moneyberg wasn't a public figure. He's paid for an Instagram account with millions of followers. He's paid for numerous press releases so he can appear like a big deal in the news, one of them being Playboy. And he's posted content on social media for years. He is absolutely a limited purpose public figure, and the courts have ruled that twice. Notice that the courts haven't responded to his request. This is a positive sign that they don't intend on hearing his argument. These three judges are going to rule on the anti-slapp very soon. All they have to do is rule according to the letter of the law. Plaintiffs are limited purpose public figures. Plaintiffs have not made the requisite clear and convincing showing that the Cornelia defendants had actual knowledge that their comments were false or acted with reckless disregard as to their falsity. Similarly, plaintiffs have not made the requisite showing that the Cornelia defendants acted with intent to harm plaintiffs' pecuniary interests. In their own words, they have asserted both prongs of the anti-slapp. This is a very simple if-then logic sequence. If both prongs of the anti-slapp have been met, then you have to grant it. In layman's terms, they have agreed that both elements of the anti-slapp have been met, which means I should recoup attorney's fees plus a $10,000 reward. I just need these three judges to make the objectively correct ruling and grant the anti-slapp. To date, I have accumulated $435,000 in total costs associated with this lawsuit and 5 years of my life. All I need is those panel of judges to correctly rule on the anti-slapp, and I win. I also want to say a huge thank you to everyone who has supported me throughout this process. A few years ago when I was down bad, absolute back against the wall, I started a GoFundMe, was able to raise money, and I can't tell you how much that saved me and helped me. Seriously, major thank you to everyone who helped me out. You have my word that I will pay it forward once I win this anti-slapp and recoup my attorney's fees. My current plan is to attend law school this August, and I can only hope that in the future I can help as many underfunded defendants as possible because I don't want any other YouTube content creator to ever experience what I had to go through. This was an incredibly challenging 5 years for me, both financially and spiritually, creator burnout. This lawsuit sucked the joy out of life. During a lot of the time, there were many moments where I would have told you there was basically a 0% chance of me reaching the finish line. Please pray that the judges make the correct ruling, not just for me, but for all YouTubers. It is very important that we have the anti-slapp motion to protect everyone on YouTube. Thanks for watching.